Hello, viewers. Today we are going to discuss the most, not most, one of the important provision of Bharatiya Nagarik Suraksha Sanhita, that is in short BNSS 2023, regarding section 35, which was earlier called as section 41 and 41A of the Code of Criminal Procedure. This section, as we all know, it gives power to the police officer to arrest a person without a warrant and without a magistrate's order in specified circumstances. Remember, it talks about the police power which they can apply for not for punishing, for arresting persons without warrant and without magistrate's order, but in specified circumstances, not all. And these specified circumstances mainly relates to cognizable offenses. However, the provisions also places safeguards against unnecessary arrest, that is arbitrary arrest. It gives protection against arbitrary arrest. Now let's see what it says. Number one point is, if we talk that police officer has the power to arrest a person without warrant and without magistrate's order, then in what condition, when? So number one point is, they has the power to arrest when a person commits a cognizable offense in the presence of a police officer. Now the very question arises in our mind is, what is cognizable offense? The cognizable offenses, if we say in a very simple language, is serious offenses compared to the non-cognizable offenses. I mean that cognizable offenses are heinous crimes, serious in nature, and non-cognizable offenses are less serious. For example, murder is a cognizable offense. Now, number one point, second provision says that there is a reasonable complaint against the person regarding a cognizable offense. Now, we have come to know that person can be arrested in specified circumstances under section 35, which talks about the power of police officer to arrest a person without warrant. First, we came to know that when they can arrest in case of cognizable offenses. But for arrest, how and when they can arrest? It says that the person can be arrested if there is a reasonable complaint made against that person that so and so person has committed a cognizable offense. Next comes, if there is credible information, that is some important informations has been provided to the police that so and so person has committed any kind of cognizable offense. In such cases also, the police has the power to arrest the person immediately. And third one is, there is reasonable suspicion that the person has committed a cognizable offense. So on the basis of suspicion also, a police has the power to arrest a person without warrant. So these are the three conditions under which a police officer has the power to arrest a person without warrant and without magistrate's order. That is reasonable complaint, number one. Number two is credible informations that has been received by them. And the third one is suspicion. Then comes number 2 point. For cognizable offenses, punishable up to 7 years. Firstly, we came to know that police has the power to arrest a person without warrant if he has committed a cognizable offense. Next is, if the offense is cognizable in nature and it is punishable up to 7 years. In such cases also they has the power to arrest. Now arrest is not automatic in such cases. The police officer must have reasons to believe that the person committed the offense and that the arrest is necessary for one or more of the following purpose. Let's see the purposes. Number one, to prevent the person from committing any further offense so that he cannot commit any further offense. So, police officer has to arrest that person. Next is for proper investigation of the offense so that the police officer can make investigation properly. They require the arrest of that person. Third is to prevent the destruction or tampering with evidences. Then comes to prevent inducement, threat, or promise to witnesses. And next is to ensure that person's presence before the court whenever required. So, in these conditions, if a person has committed cognizable offense and the offense is punishable up to 7 years, in such condition, what happens? Police has the power to arrest the person without warrant and without magistrate's order. And for in what condition? That is to prevent any further offenses, to carry on the investigations, to prevent the destructions or the tampering of evidences, to make convenience for the court whenever it is necessary that the person can be produced before the court on these circumstances and these conditions they has the power. Then comes now when arrest is not necessary. Till now we have come to know then when they can arrest and under what conditions they can arrest, in what circumstances they can arrest. Now we will see when they cannot arrest or when it is not necessary to arrest a person. If arrest is not required, here it says that if arrest is not required under the above conditions that we have discussed earlier, the police officer must not arrest and also he has to record the reasons for not making the arrest. Simply not arresting the person is not enough. According to section 35, the police officer, if not arresting any person, he has to give proper reasons for that. And that reasons should be recorded, should be kept in record. Then, the person may instead serve with notice of appearance. It means if suppose the person is, if the police officer finds that it's not necessary for in that during that time not to arrest that person, in such cases after recording the reasons for so doing, he also has to serve a notice of appearance to the person, and that person, if receives that notice of appearance, he has to appear before the police officer whenever required. Then comes the police officer may direct the person to appear before him by issuing a notice, as I have discussed it just now. Then the person must comply with the notice. This means that if the person has received the notice or he has been served with that notice of appearance, then he has to fulfill the requirement. He has to appear before the police officer. And if the person complies and continues to cooperate with the police, then he should ordinarily not be arrested. This means that if he does not comply with the requirement of the notice, in such conditions also police has the power to arrest without warrant. Then comes fifth point, offense punishable with more than 7 years, life imprisonment or death. Till now we have come to know that police officer can arrest in cognizable offenses, then offenses punishable up to 7 years, and now they also has the power to arrest a person without warrant, without magistrate's order, in the cases when it is punishable with more than 7 years or life imprisonment or death. If credible informations exist and the police officers has reason to believe that the person committed such offense, they should have the reason, they should have the proper grounds of arresting. In such cases, they can arrest without warrant. Then comes the sixth point, other persons who may be arrested without warrant. Till now we have discussed who are arrested in what conditions and for which kind of offenses they can be arrested. Now we are talking about the persons who does not fall under this category, but they are discussed in sixth point of section 35. Now these persons are: a police officer may also arrest without warrant a proclaimed offender. Number one is the proclaimed offender. What is proclaimed offender? Proclaimed offender is a person against whom a proclamation has been issued. Proclamation is what? Proclamation is a kind of notice according to which a person has to appear before the court within 30 days of his period from the date of issuance. Then comes section next person is the person found with suspected stolen property. If a person is in his is a person's possession, in possession some suspected stolen property is been found, then such cases also we can arrest. Then a person distributing sorry not distributing, a person destructing a police officer in the discharge of his uh, duty. It's not sorry, my written mistake. It's not destructing, it's disturbing. When the police officer is being disturbed during the discharge of his duties. Then a person who has escaped or attempt to escape from lawful custody. Suppose a person is already in custody and he is trying to escape the custody which is lawful in nature, in such cases also has the power to rearrest that person. Then a deserter from the armed forces, so that they can support the armed forces in one way or the other by arresting the person, deserter. Then a person involved in acts committed outside India which would be punishable in India. It means, suppose if any act is punishable within India under section and it is it has been stated as punishable or as a particular offense under section under provisions of BNS. In such cases, suppose a person has not committed it within India but outside India, in such cases also the police officer has the power to arrest that person from that particular area, from that particular country or that place. Then comes a release convict who breaches the rules made under law. So, in all, it can be said that Section 35 of Bharatiya Nagarik Suraksha Sanhita balances the police power of arrest without warrant in cognizable offences with safeguards against arbitrary arrest through mandatory recording of reasons and notice of appearance. And we have come to the end of the section. And the most important one of the important part of section 35 related is that if suppose arrest is to be made of person who is infirm or who has crossed the age limit of 60 or 60 years or above, and the offense is committed which is punishable with less than 3 years of punishment, in such cases arrest shall be made with prior permission from a police officer who is not below the rank of deputy superintendent of police in such cases. So this is all about section 35. Hope you like it. If you like, then please give a like, subscribe my channel so that I can provide you some more discussions, some more sections. So thank you. Bye bye.